please provide comments of your meeting with the UN Special Rapporteur on the independence of judges and lawyers?
It was an interesting meeting, but I think it's also important to note that the limitations that special rapporteurs have in terms of resources and what they can do around the world was striking for me. The fact that he has not been able to visit many countries to pursue his mandate, I think was deeply concerning. I think we need to begin to make the case about the importance of this mandate in especially developing countries such as mine in Uganda, where the expertise of the UN Special Rapporteur could go a long way in improving the quality of our judiciary, in improving the safety and security of judicial officers. So I do think that the mandate is a fantastic mandate, has a great mandate holder, the limitations notwithstanding, and presents an opportunity for us to engage the mandates to improve our own judiciary. I particularly invited the Special Rapporteur to think about participating as a friend of court, or what in legal terms is called the amicus, to join litigation in countries to help lend his expertise to judges and magistrates who are deciding questions about judicial independence. And I hope that he can join us in Uganda in our challenge against the financial restriction on the judiciary, the increasing abuse of judicial independence in my country.
What are the most compelling challenges of human rights lawyers in Uganda?
Well, there are many challenges, but I think that nothing is more profound than the difference between theory and practice, the difference between our commitment and signing up to normative frameworks, international and national, and the actual implementation of these policies. So I do think that we perhaps could do better in the implementation of the commitments we make. Sometimes when our leaders commit to international instruments, they don't have the political will to implement them in our country. So I do think that the biggest challenge for me has been the difference, the huge gulf or difference between policy, laws, normative frameworks, and implementation or execution of them in my country, and I think around the world.
How is the current situation of the independence of judges and lawyers impacting the work you are performing in Uganda?
The last bastion of hope for people whose rights were being abused has been the judiciary for a very long time. The attack on judicial independence, the denial of financial resources and the independence of judicial officers, the reported cases of corruption in the judiciary undermines that mechanism as a mechanism for the protection and promotion of human rights. And so judicial independence and the erosion of it is not just a concern for judges, it's a concern for every person who was looking towards or looking to the court as the place where they could protect and guarantee their rights. So yes, it does impact our work, that you're not sure whether a judicial officer deciding a politically sensitive case or a socially sensitive case like LGBTI rights in my country would act in fidelity to the law or would be influenced by extraneous factors, social, political or otherwise. And so yeah, the lack of independence of judicial officers does impact our work significantly. It makes it, for example, exceedingly difficult to get quick justice. In many cases, we have cases that have been in before the courts for more than 4 years, 5 years, because the judiciary is either afraid to dispose of those cases because they're very sensitive, or cases where the judiciary decides based on extraneous factors, not the law. It therefore means that rights will be delayed, people's rights will be trampled upon, and the opportunity for the judges to make law, to interpret law, will be missed.
Perfect. How could the UN Special Rapporteur support you or the mission of your organization?
First, we invite him to think about joining cases that we are filing in Uganda and providing his expertise to the court in Uganda in deciding cases of human rights violation, in particular cases of judicial independence. Secondly, I think that the thematic reports that the UN Special Rapporteur provides creates soft law and becomes useful document for persuading states to act otherwise, for legislative advocacy, and in many cases for even court work. So if for some reason or another the Special Rapporteur is unable to participate in cases as a friend of the court or amicus curiae, he needs to make available the reports that he makes to the UN General Assembly, to the UN Human Rights Council. Thirdly, I think to try and encourage him to do country visits. I think that academic visits are very easy to have in country. In my particular case, I'm exceedingly happy to invite the Special Rapporteur to join us for our annual Human Rights Convention in May of this year, to come and speak to people in the country, policymakers, human rights advocates, about the importance of the independence of the judiciary, and perhaps make the mandate better known to many actors in our country. This convention brings about nearly 50,000 people from across the political and government spectrum in my country. So if we can do more country visits, academic visits, because official visits might be difficult, states might be unwilling to invite them, but in cases of academic visits, organizations such as Chapter 4 Uganda is willing to host the Special Rapporteur to allow him to interface with the civil society and government actors in my country.